You want to swim? There's an ocean.
All right. Once you start now and settle, that's party deciding justice. Please be seated.
All right, good morning, everyone. This is actually the first hybrid hearing that I think our court has engaged in, and certainly the first one. And so you are all making a little history here at the Guam Supreme Court. So good morning, Mr. Nelson. Good morning, Mr. Thompson, Attorney Visosky. And I'd like to thank my colleagues in the CNMI, Justice John Manglona, and I don't see Chief Justice Alex Castro. Is Chief Justice Castro? Oh. I just want to make sure that we are all ready before we begin.
Good morning, Your Honor.
Oh, good morning, CJ Castro. And if you just give me 1 minute here, I'm trying to, here we go. Okay, now we're good. So, and now that all of the justices are on the virtual screen, we are ready to proceed. With that, Mr. Nelson, you are recognized and you may take the podium. I'm sorry, before you do so, Mr. Nelson, I'm going to ask the clerk to please call the case.
This is Supreme Court case number CVA22-004 in the matter of the application for registration of title to estate number 2959, formerly a part of estate number 49, NKA lot number 10191, Municipality of Dededo. Appearing for the petitioner appellant is Glenn B. Nelson, administrator of the estate of Juan de Torres Espinoza Sr., aka Juan Espinoza de Torres Sr. Pro Se. Appearing for the respondent appellee, Bayview Inc. LLC, is attorney Mitchell F. Thompson. Appearing for the respondent appellee, Blue Ocean Development LLC, is attorney John A. Visosky. The panel consists of presiding Justice F. Philip Carbolito, Justice Pro Tem Alexandro C. Castro, and Justice Pro Tem John A. Manglona. Mr. Nelson reserves his remaining time after he presents. Attorneys Thompson and Visosky will split their time.
All right, Mr. Nelson, you may now take the podium. You are recognized. If you could just raise that microphone a little, that would be great.
Chief Justice Carbolito, Justice Manglona, Justice Castro, may it please the court. I trust that the Honorable Court has read the case file, briefs, and moving papers submitted by the Juan Senior Estate, and I respectfully ask not to waive anything contained therein that may not be presented during this proceeding. I come before you today seeking to vacate the lower court's judgment and ask for such other relief that the Honorable Court may grant. This case stems from the initial attempt of the Juan Senior Estate to petition for registration of title to estate 2949, formerly a part of estate 49, now known as lot number 10191. The Juan Senior Estate was deprived of the right to register lot 10191, a piece of land encompassing 13,534 square meters in the municipality of Dededo, fronting to Monbay. For the record, lot number 10191 is not already registered property. It is a plat of land of which history and clear chain of title and ownership can be traced as far back as 1918, a fact that the lower court time and time again has blatantly failed to recognize. The action of petitioning for the registration of the lot was the first step towards compliance with the land registration laws of Guam. Attached to the petition was a property map that was accepted and approved by the Department of Land Management and recorded as instrument number 866552. A review of the map reveals that there are two separate lots that overlap the boundaries of lot number 10191. The map shows that 13 square meters of lot 10113-R3 which encompasses 87,575 square meters, overlap into 10191, as well as 13,521 square meters of lot 10113-3, which encompasses 100,000 square meters, overlapping lot number 10191. The lower court did not ignore the overlap, but rather totally disregarded any and all evidence, material, and facts submitted by the Juan Senior Estate in support of our position that the lot was subsumed, swallowed, and disappeared into 10113 under questionable circumstances. By way of filing, co-objectors represent that lot number 10191 was registered when lot 10113 was registered in 1981. However, a complete review of all cited prior cases in the court below, including the 1981 land registration proceeding, reveals nothing whatsoever that indicates, identifies, or references that lot number 10191, formerly known as Estate 2959, formerly a part of Estate 49, was ever a part of that particular proceeding. We continue to argue that the 1981 decree did not dispose of the interests of Juan Senior. Again,
Mr. Nelson,
yes, sir.
the initial petition to register was made in 1978, and wasn't Estate 49 the substance of that 1978 case?
As far as our research has shown, and what is available at the public records, public land records and land management, Estate 49, 2959 were not seen in any part of that particular proceeding. That particular proceeding was primarily to register lot 10113 as well as Estate 431. So it was established then at the point of petition that 10113 was in essence 431.
So, all right, go ahead.
Okay, sir. And with all due respect, Justice, I do have a section here that does address that particular issue. If I may. We continue to argue that the 1981 decree did not dispose of the interests of Juan Senior. Again, there is no prior proceeding that has addressed the merits of the registration of Juan Senior estates recorded in lot number 10191. There wasn't and still remains no public land record at the Department of Land Management for the consolidation of the interests of Juan Senior estate into 10113, a fact that was confirmed by the Department of Land Management. In fact, public land records reflects the interests of Juan Senior remain intact to this day. If the assertion by co-objectors that the registration of lot 10113 in turn registered lot 10191 is true, then obviously the historical record on file with the Department of Land Management should be able to explain not when, but more importantly, how. How was the interest of Juan Senior estate extinguished, disposed, or taken? Prior rulings from the court down below seem to be working on the false premise that Juan Senior sold his interest, which was purchased from his mother in May of 1918, a bona fide purchase, to his brother Louis. Juan Senior died July 18, 1918. His wife passed soon thereafter. When and in what manner did he release his interest in the estate to his brother? To get answers to these questions, a reasonable person must and can only rely upon historical records contained in the public land records of the Department of Land Management. In our moving papers and briefs before the court below, we assert that there was never any constructive notice given or even attempted to be given to the heirs of Juan Senior. To this point, and upon information and belief, only 2 of the 6 children of Dolores remained on the island during the war. Before there was a gun beach, and even before 10113 was created and registered in 1981, my efforts on behalf of Juan Senior estate included filings of abstracts of titles, which is also a requirement of the land registration law. The request for abstract of lot 10191, formerly known as 2959, was sourced between 2005 and 15. Each abstract clearly lists the relevant historical transactions and corresponding unbroken chain of title for lot number 10191, dating back to 1918, and in the case of Estate 49, 1894. With respect to lot 10113 and 431, the abstract, along with a certain case law, recognized that lot 10113-1 is actually a part of a larger tract of land known as Estate 431, title to which has been recorded in the name of Luis Espinosa Torres since 1915. Also within a proceeding heard before District Court of Guam Appellate Division, a land appellee attempted to register that lot 10113-1, Gotnya Derido, consisting of 11 hectares, based on a 1938 deed executed by Juan Leon Guerrero Torres in favor of appellee. It wasn't clear from the decision of the court down below if a finding was ever made with regard to the validity of the deed, and that the record did not indicate under what basis Juan Leon Guerrero Torres obtained an interest in the property. Further, that evidence did show clear chain of title through Luis Espinosa Torres, the father of Jose and Negadog Torres. Within this proceeding, the 11-hectare plat was described as a tract, a parcel of land lying and being situated in the place of Gotnya, Municipal District of Derido, Guam, containing a superficial area of 11 hectares, bounded on the north by the property of Juan Espinosa Torres, deceased, on the east by property of Baldomero Perez Minor, and on the south by the property of said Baldomero Perez Minor, and on the west by government of Guam, government land, and the ocean. The High Court reversed and remanded the matter to the court below with directions to deny that particular petition for the 11 hectares. Notice must be taken and emphasis must be added to the fact that lot 10113-1 was part of 431, and Estate 431 was adjoined by property owned by Juan Espinosa Torres and Baldomero Minor. I again emphasize that Estate 49, consisting of 11 hectares, and Estate 2959 were never part of Estate 431, nor 10113-1, 10113, or any derivative thereof. Moreover, a reasonable diligent research of record would have revealed such facts as to proximity of Estate 49 and Estate 2959 as adjacent property in relation to metes and bounds of lot 10113, Estate 431. But the 1978 abstract of the 1981 petition did not contain any reference of Estate 49 and Estate 2949, nor is there any evidence of constructive notice concerning its location as adjoining the lot subject of the 1981 proceeding. Moreover, local law further requires that any conveyance of property be done in writing. And in this instance, there is simply no such conveyance instrument whatsoever that shows that lot number 10191 was distributed, transferred, leased, mortgaged, or any other change in status of the recorded interest of Juan Senior's estate. The 1978 abstract, the 10113-431, does not have any reference whatsoever to the Juan Senior estate and its interest in 2959, yet the lower court will not recognize them, both Estate 49 and 2959, as newly discovered property. More egregious is the fact that the lower court's assumption of facts in this regard continues to be erroneous. To address the lot subject of this registration action as already registered land, as wrongfully adjudicated by several courts of the Superior Court, finding that the Juan Senior estate has no interest in the subject property is simply contrary to the historical records and information contained within the Records Division of the Department of Land Management. The 1978 petitioner and predecessors simply attempted and seemingly succeeded to claim more property than was legally permissible. There were no heirs of Juan Senior that were a part of that proceeding. This appeal is based on facts, not creative wordsmithing. I have yet to see any cited case, authority, or statute, and there have been many presented, that could dispose the interest of an estate and real property without due process, equal protection, and that would cause the person named on record as the owner to not be entitled to the land for the estate or interest therein specified. By granting summary judgment, the court down below failed to adjust its conclusion accordingly for reasons that are still unclear. I continue to assert that the lower court failed in its duty to fully consider the Juan Senior estate's briefs, oral arguments, and for its subsequent misapplication of applicable laws. I ask that the court take a step back, rely solely on the facts of record at the Department of Land Management, to include such circumstances of evidence that was not available at the time of prior lower court proceedings. There remain genuine issues of material fact as to the ownership of lot 10191, its size, and more importantly, its location in relation to lot 10113 that would likely require a court-ordered resurvey of the lot, or at the very least, a call for examination of conflicting abstracts by a court-appointed examiner. While I understand that such authority is discretionary, The material facts at dispute warrant exercise of such discretion. As called for in my opening brief, a full examination of abstracts for both Lot 10191 and 10113 will reveal the truth. The truth is, there's no instrument on record, as case may be, that is marked or shows the date of filing along with the volume and folio that the land, estate, and interest of Juan Senior was ever extinguished in the new certificate of title that was issued for 10113 in 1981. We must be allowed to proceed with the registration of title to lot number 10191, or we must be afforded the opportunity to proceed to trial on its merits, considering the granting of summary judgment was erroneous and premature. The heirs of Juan Senior deserve their day in court. I respectfully ask to reserve any time I may have remaining.
Mr. Nelson, if I may,
Please.
you raise very valid points. Your research has been meticulous. And had you been the advocate in the earlier proceedings, maybe things would have been different. However, this court is constrained by principles of law, and we don't have that type of discretion that you are mentioning, that we can just decide in the first instance. The apparent issues that you raise in the lower court in this case, there are the arguments you make have been, and although you probably have made it a lot better before this court, have been raised in other proceedings, the probate action that you referred to, the quiet title action, the probate action before then Judge Merriman, quiet title action that was, can't recall, it was the judge, it could have been Judge Paris. And the estate was represented then by your father, former Senator Ted Nelson. The adverse rulings were never appealed in those cases. And so you've read the briefs of the appellants and their principles of law, and this fancy term is res judicata, which simply means that the issues and the arguments you make today, you made before the trial court down below, were raised in similar, maybe not identical, and maybe not as meticulous as how you are advancing it today, but they were made in substance in the lower proceedings, and those adverse rulings were never appealed. So under the principles of law that govern how we review cases, we are constrained. And I've given you the opportunity to state your case, because for the record, you raised very valid arguments, in my mind, very valid points. But this court is constrained by principles of law that we must adhere to. And I think you need to understand that.
I think I do, Chief Justice, but with all due respect, I do understand the principles of res judicata as clearly explained by the co-objectors. But at the same time, I've come to realize that with all the cases that are being cited, the cases that were not appealed, as you make reference to, and each case is kind of unique in its own sense, in that they all, one thing that it does have in common is the fact that they all revert back and cite the 1778 decision, the 1981. At this particular stage, based on the record, we were not given a chance to fully have a chance at due process, that opportunity to be heard, due to that lack of constructive notice back in 1981. I understand that the other cases, the one that went before the Honorable Barcenas, even they recognize then the confusion that existed. They recognized the tracing of history, the unbroken title, but yet they jumped straight to 1981. And In the case of Perez, he identified bona fide purchaser. Juan Sr., my great-grandfather, was himself and also a bona fide purchaser. Before the case of the Honorable Kathy Merriman, that was perhaps the most interesting, because while Ted Nelson is my father, he made an attempt to represent the estate as an administrator, and that request was denied. But through the same court, 193-48, a couple years later, it was reopened by yet another Honorable Perez, who also heard 77908. He allowed us, and we were very specific when we requested for the administrator status, it was specific to execution of the map and claiming title to what were then recognized as the inventory of the estate as 49 and 2959. It was approved, Your Honor. I understand the principles of res judicata and how it relates to the others, but at the same time, in 2011, the estate was approved to go ahead and proceed, at least specific to those particular lots. And as we go through the motions of the land registration, we got to understand and recognize that the registration is for 2959, not for 49. Juan Sr. never owned 10113, never owned 431. But yet at the same time, we find ourselves in a position of trying to get the court to understand that there has to be an explanation. We're not here based on false entitlements. We're here because we feel that based on the record, Juan Sr. and the heirs of.
And I follow your argument. I understand that there were the questions of what happened to estate 49 or 2959 were not addressed, at least from my review of the record in those proceedings. But for it to be raised in the first instance in this particular proceeding in your attempt for land registration, they could have been raised in the earlier proceeding. And the principles of res judicata is, even had it not been directly addressed, if it could have been raised.
And I believe
they're broad enough to cover that.
Yes, thank you, Your Honor, for that. And I do believe they were addressed in the lower court proceedings. But the frustration of it all, it seems like the lower court had seemed time again to fail to recognize certain facts, a record, and just keep going back to 1778, which was approved in 1981. All the denials, and every case was unique. Time and case, situation with family, medical reasons with my mom, my dad. But at the same time, when the opportunity presented itself and it was approved by the court for my cousin and I to reopen the probate, we practically had a duty to reopen these issues and explain why the lower courts may have failed us, if not in those res judicata principle citations, at least with the 1778, the circumstances that surrounded the 1778 registration proceeding. It's clear, Your Honor, that in the record, Juan Sr. has no interest in 10113 or 431. But yet in registering 10113, 49 and 2959, both separate lots, disappeared. I don't know if res judicata does us any justice, considering that that was a wrong that must be made right. And that's part of the, again, I do not come before you as the administrator of the estate trying to seek something that is not supported, that is not a false entitlement. There's the clear chain of history could be clear, unbroken chain of history. Title could be established, but yet every court that has heard it, whether it's for situations of quiet title or whether it was for the lower courts, there was 1025-05, that's Barcina's TNN, and then the 77908, and then you had the Merriman decision with respect to a probate. Those two prior decisions relied solely on the 1981 proceeding. In the Perez decision, he actually makes reference to the fact that that there was the issue of bona fide purchaser. My great-great-grandfather was also a bona fide purchaser. But where are the protections afforded to him? And it's so interesting is that the certain protections afforded to bona fide purchasers should not be intended to extinguish the rightful claims and what we now see through the public land records as unregistered property. Then they raised the issue of the map and the timing of the map. I mean, no one went as far as saying the map was in error. Our position remains the same, that title to the land will be established upon completion of the registration process, God willing. But at the same time, we understand that it's not because of a timely preparation or presentation of a map party to a land registration petition. The significance about filing of that map for lot 10191 is that it was approved by land management. In and of itself, more superior to that of a drawing or a sketch submitted with the petition. Superior in the sense that the meat and the bounds were determined to be true and accurate based on recordings of facts contained in public record and land management. The boundary of lot 10191 is the same as it was back in 1918. As per a record of filing in volume and folio recorded at the Office of Registry of Lands, Deeds, and Titles of Guam. And we can, at the very least, at least through this particular exercise with the case before the Honorable sends on, there were opportunities. We submitted the abstract. There was some confusion. Everyone reverts back to the 1978, but because there was conflicting abstracts, I feel that the court should have exercised its discretion, although it's discretionary and it's up to them. There was enough presented, Your Honor, to actually say, let's take a step back. Let's get an examiner record. And I believe it's supposed to be a court-appointed, an attorney, and they're there to review the facts and make that determination. If that were to have been done and they told us, Juan Sr., you're done, we will not pursue this. But because the evidence is still clear, nothing in those prior cases before the Honorable Barcenas, and nothing seemed to have exhausted the interests of Juan Sr.'s estates based on the records at land management. 1778 had nothing to do with 49 and 2959, but yet we're being denied the opportunity and the ability to claim what is on the record, still rightfully that of, or within the interests of the estate. And every time it was brought to court under different circumstances by different parties, 1778, PR, 1778, land registration, 1981. There were 15 people a part of the 1981 proceeding, Your Honor. None of them were heirs of the Juan Sr. estate. I understand the limitations of the court, but at the same time, I do recognize that the courts over time can make right what was wrong in the past. And I did assert to this, decisions of the past can change over time. Circumstances change, more evidence is presented. And I feel that that is truly the case in this regard. If we're being told we have no interest in lots that are not part of a proceeding, that were separate lots.
Let me just say, as an example, if we were even to assume and rule in your favor, and you go downstairs, you prevail, and 20 years from now, someone raises that there are other matters that were not brought before this court in this particular proceeding, And during those 20 years, homes were built, the property was developed. And then it turns out that there are questions again regarding title to the property. If you put yourself in that position, that now then, after 20 years and the finality of this judgment, it's now going to be open, it's going to be reopened and issues looked again, whether in fact you are the true, or the Nelson family is the true owners. I don't think that's going to sit very well with you. And so, you know, that's kind of the circumstance that this court finds itself in viewing this case as a result of the two prior proceedings that have addressed land ownership relating, maybe not satisfactorily, but under the rules of that apply to legal proceedings, those judgments are final, and that has a significance, because a very important principle in the law is finality of judgments, so parties can know their respective rights and duties, and that's the circumstance that you are in right now.
If I may, Your Honor,
Yeah.
I stand before you as the administrator of one senior estate. I represent not just Ted Nelson, I represent a rather large contingent or family. And if in 20 years, there is a claim to the estate, a rightful claim, a failed process, an injustice, then I will gladly have to try and defend it. But I cannot say, hey, I got the land already. Even though there was a knowing, a factual taking, and that is clear. It was a taking. Whether it's unlawful, whatever, it affected the family today. And if someone is placed in my situation 20 years from now, then I would actually invite them to fight for it just as much as we're trying to. It's the only right thing to do, Your Honor. There's just too much at stake.
Thank you, Mr. Nelson. I appreciate it.
Thank you.
Any
Sir,
questions?
Mr. Nelson,
Just a second.
was lot 10191 uttered in the three cases in 1978, 2006, and the third case? Was it ever mentioned, this particular lot number?
10191, Your Honor, thank you for the question. 10191 was actually a designated lot number that was assigned to it by the Department of Land Management by way of instrument number 866552. And that was done fairly recently. Prior to that, it was formerly known as 2959, formerly a part of 49, sir. And you will see 49 reference in the prior cases. In fact, I believe the Paris case 779, I believe that one was specific to 49. In the case of Merriman, Honorable Merriman 19348, there was specific mention of 2949 and 2959 and 49. However, we had not yet obtained that designated, that number that was assigned to it by land management, lot number 10191. That was only obtained, Your Honor, after we obtained the standing of the court to sign this map, to submit it for the purposes of registering the land. That's why we went to the court and we did exactly what we thought we were authorized to do, is to go and chase the registration of this piece of land of which interest had never been adjudicated in any prior court below, even
Okay.
in the 1778 proceeding.
All right. Oh, yeah. How large is this 10191, and what are the improvements in this property?
The current condition of, I believe on lot 101 R3, the portion that overlaps 10191 is undeveloped. And the portion, I believe that 10113-3 is totally undeveloped. This is, but I believe that the beach bar might be in R3. a portion of R3. Again, mindful, Your Honor, that we're dealing with 13 square meters in one particular lot that has 87,000 square meters, and then another particular lot that encompasses 100,000 square meters. I mean, 187,000 square meters, and another that represent 100,000 square meters. Our lot's only 13,000 square meters, but it just happens to be those two particular lots happen to overlap into what we have identified to be the true means and bounds of the Juan Senior Estate, at least as it relates specifically to 2959, separate from 49.
Okay, thank you.
Thank you, Your Honor.
Thank you, Mr. Thompson. I understand that you've decided to equally share your time. So
That's correct.
you're recognized, Mr. Thompson.
Mr. Chief Justice, may it please the court. I don't think I have much to add to the joint brief which we previously submitted. Of course, I'm more than happy to address any questions that the court may have.
You have articulated the position of your client quite adequately in reference to your brief. I don't have any specific questions for Mr. Thompson. Justice Mingalonia, Chief Justice.
No questions, no question.
All right, thank you, Mr. Thompson. Mr. Vasosky.
Thank you, Chief Justice, and may it please the court. I don't have much further to add. I would like to attempt to address the question raised by Justice Maglonia in regards to Estate 49 and whether that was registered back in 1981. And we did point to that in our briefs, our joint brief on page 5. And that citation was to a decision in order in the probate case PR 193-48. I'll just quote briefly. On July 20, 1978, Calvos filed a petition to register certain properties, including Estate 49. On March 11, 1981, the Superior Court issued a decree of land registration registering Estate 49 and other properties as Lot 10113-R2. And I understood that to be Justice Maglonia's question about whether Estate 49 was registered. Yes, it was. And then the court continued to explain, Justice Merriman, now Justice Merriman continued to explain in that decision. Subsequently, Lot 10113-R2 was subdivided into lot numbers 10113-R3 and -3. Those are the two lots that are at issue here. And Justice Merriman explained, as such, Estate 49 later became known as Lot 10113. So they are the same properties.
I guess the question is, as Mr. Nelson articulates, Estate 49 had its own delineation. And so when I said it may have not been adequately addressed, I read those references and conclusions. The description of how it was subsumed, I think, is what may not have been adequately explained.
And your Chief Justice, I cannot explain in great detail the history going back. Yes, our brief focused on the res judicata aspects and the registration itself. I cannot explain exactly how the Estate 49 and Lot 10113-R2 became subsumed and overlapped.
And I think that describes the frustration of Mr. Glenn Nelson. And so when there are references in the briefs of the vexatious litigation, that doesn't exist in my mind, FYI.
I understand the frustration. I guess I would just point out, the fact that it was addressed clearly to the extent the Justice Merriman explained Estate 49 became known as Estate lot number 10113-R2. So it was clearly addressed then. There was no mistake that those were different lots. If it was inadequately addressed at that point, that's where it should have been appealed, of course, and this matter resolved, because it was clearly explained to the family at that time. Thank you.
I understand, Mr. Vasosky, and thank you for that clarification.
Nothing further. Thank you, Your Honor.
Any other questions, Justice Manglonia and Chief Justice Castro?
Question here.
All right, thank you. Thank you, Counsel. Does Mr. Nelson have any time remaining? Madam Clerk? All right, I'll give you you have 5 minutes to practice.
Thank you, Your Honor. It will not take that long. To Mr. Attorney Fiskowski's point, he's correct. 49 is 49. Everything before you today is to register a lot that's called 2959. Separate and apart. Separate and apart. That was designated a new lot number 10191. All respect to Attorney Justice Merriman. 49 was not 2959. Thank you, Your Honor.
Thank you, Mr. Nelson. Thank you, Mr. Nelson and counsels. The court will take the matter under advisement, and for the record, Mr. Nelson, that was an excellent pro se brief and one that I've never seen a pro se litigant file in this court. And the court will take the matter under advisement, and this court stands adjourned.
All right.